Good morning, everyone, and welcome to the third of our series of web-based seminars entitled Best Practices in TB Control. Today's topic is legal interventions in TB control. My name is Bill Bauer, and I'm Director of Education and Training at the Charles P. Felton National Tuberculosis Center, a component of the Northeastern Regional Training and Medical Consultation Consortium at the New Jersey Medical School Global Tuberculosis Institute. Today's program is sponsored by the consortium in collaboration with our three sister regional training and medical consultation centers. This web-based course will explore successful and innovative approaches to implementing legal interventions in TB control programs in the United States. Experts will share legal and ethical considerations as well as hands-on experiences, practical steps, and the legal tools that can be used to improve outcomes of case management, treatment, and contact investigations. We're going to look at what goes on at local, that's city or county level, state level, and federal level in terms of using legal tools to intervene to improve TB outcomes. The objectives for today's program are straightforward. You will be learning about the circumstances in which legal interventions may be used, the ethics, the rights, and the principles involved, and then practical details about documentation and communication between different levels of the public health system. Our faculty today are Dean Lawrence Gostin, Dr. Sonal Munsif, Ms. Kimberly Tendrich, Dr. Michael Lozardo, and Dr. Francisco Eberhoff. Today's conference will consist of 4 parts. After this introduction and some housekeeping details, there will be a presentation about public health ethics, patients' rights, and the right of the public to be protected from infectious diseases. Next, we'll learn about the history of legal interventions in New York City's TB control program, the different levels of commissioners' orders that they use, and the documentation necessary to present a case to legal authorities. This will be illustrated by a case study. Third, we'll have a chance to learn about the basis for legal interventions in TB control in the state of Florida. We'll also hear a case study of legal intervention that required collaboration between county and state. Fourth, we'll learn about the federal perspective, when intervention is needed if individuals with infectious TB travel interstate or internationally. If time permits, we'll have 1 or 2 questions after each speaker. And at the end, there will be time for general discussion, for your comments, and for any last questions for our panelists. So we'll start today with an overview of public health ethics, patients' rights, and the right of the public to be protected from infectious diseases. This will set the stage for our understanding of how city, county, and state TB programs and the federal level can use legal interventions and when this is appropriate. I'd like to turn to Lawrence Gostin to explore these subjects. Dean Gostin is an Associate Dean, Professor of Global Health Law, and Faculty Director at the O'Neill Institute for National and Global Health Law, Georgetown University Law Center, and a Professor of Public Health at the Johns Hopkins University and Director of the Center for Law and the Public Health at Johns Hopkins and Georgetown Universities. He's an internationally acclaimed scholar who's authored hundreds of professional articles, chapters, and books, and he's been on the editorial board of some 25 professional journals. Dean Gostin?
Hello. How is everyone? I'm going to be talking about public health powers, particularly quarantine, which, as we all know, is steeped in history. It goes back to biblical times and the ancient cities. But the practice of quarantine continues to evoke a great deal of controversy and concern. And the reason it does is because it pits a number of fundamental values against one another. On the one hand, there's the issue of individual autonomy, bodily integrity, and liberty, and on the other is the protection of the public's health. And of course, public health concerns are heightened by recent drug-resistant forms of tuberculosis namely multi-drug resistant tuberculosis and extensively drug-resistant tuberculosis. And one can go to the recent case that was very well publicized in the spring of 2007, where a person who had then been diagnosed as having XDR-TB, but later it was corrected to MDR-TB, traveled to multiple countries against medical advice, and it showed the inadequacies of our modern laws and also communication systems, since there seemed to be inadequate communication between our public health authorities and those in foreign countries. And then, of course, he presented himself at the Canadian border, and when he did, despite having orders to the contrary, the border guard let him through because he looked well. And once he came into the country, the CDC issued a quarantine order, which was the first federal quarantine order issued since 1963. And you can see on the slides his various paths between North America and Europe. There are a range of interventions that are talked about for TB in particular, but also for communicable diseases more generally, including isolation and quarantine, directly observed therapy, cordon sanitaire, social mixing restrictions, international travel orders and border restrictions, testing and screening, and in other countries, of course, vaccination requirements. Most people who know public health well know that there is a difference between isolation and quarantine. But I think it's useful to try to define those two terms, even though in common parlance they tend to be used interchangeably. Isolation is the confinement of a person known to have an infection for the period of time of communicability. And quarantine is the detention of an individual who is not known to have an infection, but has been exposed to disease, and there is a concern that the person may in fact have it. So even though the CDC order is called a quarantine order, in terms of the exact parlance, it should be an isolation order. There's been a lot of discussion of many of these other interventions that I've put up on the slide, mostly in the context now of pandemic influenza, but several of them do apply to tuberculosis. And of course, tuberculosis is the really defining disease for the use of public health powers. I want to now move to the next slide, which is going to begin the real meat of my conversation with you today. And this is what the legal authorities are for isolation or quarantine. They're basically, and this is putting it a little oversimplistically, but I think broadly correctly, three different levels of power. One is at the state or local level. Many local governments, local public health agencies have the power to quarantine. They have the power either as a delegated power from the state, or a few of them have it as an independent or home rule power. And then, of course, all states have quarantine power. And then you have power on the federal government or internationally. And one of the big questions that arose in the spring of 2007 is the question of coordination of these powers. This is really the biggest issue. I know when I give congressional testimony in relation to public health powers, senators or congresspersons usually ask one major question, which is what I call the who's in charge question. But in this case, who is the lead government? Is it the local government? Is it the state? Is it the federal government? Is it the WHO or some international authority? And even if it is, if you could identify which government it is, the question is who is the lead agency. So in the federal government, is it the CDC? Is it Homeland Security, HHS, Department of Justice, etc.? So now let me look sequentially at these three levels of power. First, state and local, then federal, and then international. As you can see, the authority for isolation and quarantine at the state and local level is derived from the police power. The police power is a constitutional authority where states have the power to safeguard the health, welfare, safety, and morals of the population. Constitutionally, states have these powers because they actually pre-existed the federal government as governments, and as a result, the Constitution doesn't need to give states these powers. Their police powers actually preceded those of that were given in the Constitution. The problem with state power is that although all states and localities have this power, they're very antiquated. In many cases, state or local laws go back 100 years. They tell the history of infectious diseases, ranging from cholera, smallpox, through to tuberculosis, polio, and then through to HIV/AIDS and SARS and the like. They're also very fragmented. State laws are not uniform. They're very different in different jurisdictions. As a result, there have been two efforts to draft model public health statutes, and I was involved in drafting both of them. The first one was after the anthrax attacks in October of 2001. The General Counsel of CDC and CDC itself asked my center to draft the Model State Emergency Health Powers Act. We drafted that in consultation with many others, and it was, although controversial in many senses, also very successful. Currently, about 38 states have adopted the Model Act or part of the Model Act. Most of the powers in the Model Act have to be triggered by a governor declaring an emergency. And so normally this wouldn't apply to TB, which is, as we all know, an endemic disease. There was a more recent 2003 Turning Point Model State Public Health Act, which does not require an emergency declaration. This is by far the most ambitious, modern, important piece of model public health legislation certainly ever in the United States and maybe worldwide. There were multiple public health groups and governors and others that were involved in this drafting, and as a result, it's really an excellent model, but few states have yet to adopt it, although a few have. Well, that's an outline of state and local authority. What about federal quarantine authority? Well, the Public Health Service Act of the United States gives the CDC the power to issue regulations to prevent the introduction, transmission, or interstate spread of communicable disease into or within the United States. But the spring 07 XDR, or now MDR-TB case shows some of the weaknesses in this federal law. First of all, the federal law only applies to a very small number of infectious diseases. TB is, of course, one of them. And so whenever you get a new or novel health threat, the president actually has to issue an executive order to include it. And so this can be very reactive, not forward-thinking at all. So, for example, during the SARS outbreaks, the state of Alaska wanted to exercise public health powers when a ship was coming in from Asia into the port of Juneau, and it turned out they didn't have the power to do it. And so that's an example of narrow state power, but the same would be true of the federal power. The president actually had to issue a special order stating that SARS was a quarantinable disease. The CDC regulations also have a very narrow range of powers. They do apply to quarantine, but not necessarily screening, contact tracing, directly observed therapy, and the like. And probably most fundamentally flawed, the federal regulations have no specific provisions for due process. In the spring '07 case, the CDC did offer this gentleman due process, but it's not embedded in the regulations. And so it's possible that a court would find the current federal quarantine regulations unconstitutional, which of course is an unsatisfactory position to be in. The CDC, to their credit, has long recognized this, and they have tried for many years to reform the federal regulations. And a couple of years ago, they did finally do so. What they did was to propose new federal regulations. For those of you who are not aware of how new regs are introduced in the United States legally, the CDC basically has to post them, or any federal agency, on the Federal Register, and then the proposed rules have a notice and comment period, and then they can be put into place. But so far, the CDC's proposed quarantine regulations have not been adopted. They do cure several of the problems in the current regulations. They have a much broader scope that are not limited to specific diseases. They have reporting requirements to the CDC. They have health alerts to crew and passengers. They require airlines to collect and disseminate information. And they do introduce due process protections. I don't think they're adequate, but they exist, and they're really obviously much better than the non-existent ones at present. And so we're waiting for those new regulations to put into force. We don't know when or if they're going to come into force, because these proposed rules have been controversial, particularly because of potential costs that were perceived to be placed on the travel industry. Federal quarantine, as well as state quarantine, of course, are not simply governed by a statute. They're also governed by constitutional law. And, of course, the Constitution reviews all federal and state statutes. And because quarantine involves a deprivation of liberty, the Supreme Court uses its very highest standards of constitutional review. They require the state to have a compelling state interest, a very narrowly targeted intervention, to use the least restrictive alternative that would be successful, and, of course, as I've mentioned, to have a procedural due process. There have been a number of cases, particularly at the state Supreme Court level, making all of these points, and the federal Supreme Court has indicated it would do the same by analogy through mental health civil commitment cases. And then finally, there are international dimensions. Any action by the United States hopefully would comply with international law. But international law and U.S. law is in many ways inadequate to prevent the kind of things that occurred in spring of '07. First of all, the federal regulations are intended to prevent the importation of disease into the United States, not the export of disease to other countries. And so when this gentleman got on a plane and went somewhere else, it's not at all sure that we had the power to stop him. Of course, we could have quarantined him here in the U.S., but maybe not the jurisdiction to prevent him from traveling. Secondly, there are problems about extraterritorial jurisdiction. The United States wanted foreign countries to isolate this individual when in that other country. But the question arises whether U.S. law allows quarantine in other countries. Those countries, of course, can quarantine him under their laws, but it's very doubtful whether or not we could require his quarantine under our laws outside the United States. And then finally, there's the question of whether or not we have adequate protection against the importation of communicable disease generally and TB specifically into the U.S. And here, the Institute of Medicine had a committee and issued a report. I was on that committee that looked at what they called quarantine stations. These are really border stations placed in the U.S. ports of entry. And the IOM came to the conclusion that the border stations were too few, inadequately staffed, insufficient powers, and inadequate protection against importation of disease into the U.S., and made a number of fundamental recommendations for change. Again, the CDC, to its credit, actually commissioned the IOM report and was highly cooperative in trying to change, and has been changing and plans to change and upgrade border stations throughout the United States. The major portion of international law involved here is the international health regulations. Probably the most important thing that the World Health Organization has done legally over the last 50 years maybe was the new international health regulations in 2005. Of course, it also had the Framework Convention on Tobacco Control, which was very important as well. But the international health regulations, what people call the IHR, allow international law to govern for public health emergencies of international concern. So one of the immediate questions that arises is whether XDR-TB qualifies as such a disease. A WHO task force said no, that it didn't qualify. However, I'm and other international law experts quite skeptical of this and think that if there were a serious spread of XDR-TB across regions or countries or the world, that it would indeed be a public health emergency of international concern. The international health regulations allow countries, they authorize countries to use compulsory powers like quarantine, directly observed therapy and the like, to stem the tide of infectious diseases. So now let me try to conclude and really draw together many of the things that I've said, but also to add a few things. From a public health and law point of view, there are at least 6 things that we could do urgently to improve control of TB in the United States and internationally. One would be to improve surveillance. Surveillance capacity, particularly for MDR and XDR-TB, is critically important. Secondly, that we have to make sure that non-pharmaceutical interventions, public health strategies, respect human rights. The International Health Regulation stipulates this very, very clearly. But of course, human rights include not only the right to liberty, but also the right to health. 3, we need to develop better diagnostics. We need to be able to determine more quickly the presence of TB, and particularly drug-resistant forms of TB. It was embarrassing for public health authorities, even though to all of us quite understandable, that in the media, first of all, it took so long to identify that he had a drug-resistant form, and secondly, that it was diagnosed as XDR-TB when it was MDR-TB. We know that these are a matter of degree, but the public perception was damaging, I think, to public health. 4th, we need to better manage the synergy between XDR-TB and HIV/AIDS. As we all know, there is a very strong interconnection between these two diseases and epidemics, and controlling one can very much help control the other, and we need to bear that in mind and have a number of joint programs. 5th, we need to create new antibiotics. Along with diagnostics, it's almost embarrassing that we're still using many of the same antibiotics. We're getting new ones, but we need to get better ones more quickly. And then 6th, we need to improve health system capacities, particularly in developing countries. This is something the IHR strongly recommend. Most people in international and global public health believe that one of the keys to improve global health is to make sure that we improve public health and healthcare system capacities in developing countries. This will require a lot of financial and technical assistance from the United States and other developed countries. But although there's a lot more that's being done, a lot more needs to be done. Well, I'll therefore conclude by saying that the importance of law in this area is that, 1, we need to have adequate public health powers that are modern, with a full range of authorities, and strong enough to combat the problems that face us. But we must do so by respecting the human rights of individuals, and above all, always rely on the rule of law, because we must trust in our judicial system to make sure that we exercise public health powers in a fair, non-discriminatory way in accordance with the rule of law and a procedural and substantive due process. So, I thank you all. I look forward to answering any questions, and that's the end of my formal presentation.
Thank you very much, Dean Gostin, for sharing your knowledge and experience with all of us. The concepts and the principles that you've outlined and the issues you've raised show the path as well as pitfalls to using legal interventions as a supportive strategy in working to eliminate TB as a public health problem in our own program areas here. We have time for some questions now. There is a question box that you can use, and if you type in a question, send it to me, Bill Bauer. I'll bring it to the attention of the speaker. But we will give priority to verbally asked questions.
And it looks like your first question is from Karen Lucy at AZ Department of Health. Your line is open.
Karen Lewis, where can you find the link to Turning Point, the Model State Public Health Act?
Oh, yes. You can find that on our website, which is www.publichealthlaw.net. And then we have a box for model laws and resources, and it'll link to there.
Why is it that few states have acted on it? Is it just too assertive? People are uncomfortable about giving public health more power, or is it just that the 2001 seemed to, in people's mind, to be adequate?
Well, it's a very good question, and I have a very strong opinion about it. I mean, I think it's really mostly all political, because during the Model State Emergency Health Powers Act was adopted because it was in the public intense period following 9/11, anthrax, and it got huge amount of publicity. The publicity was reacted to by politicians, and everybody was very keen to adopt it. At the time, they asked for something, that didn't require an emergency, and we gave them something far better, but it's kind of slipped below people's radar screens, and so we need, dedicated public health professionals like you to, go ahead and, propose it to your legislatures. I mean, the state of Montana, for example, recently did that, and after a period of time, the state did adopt it.
Mark Lobato with CDC, your line is open.
Hi. Part of this legal framework we're talking about and that we apply locally is using the least restrictive measures to isolate an infectious patient. That turns out in reality in many areas to be the county jail, which I think is definitely a questionable location to isolate patients. Do you have any thought on developing regional medical facilities so that states can share costs to have adequate treating facilities for patients who may need isolation?
Yeah, I think that's it's a really important question, and there is a body of case law. I've got a book called Public Health Law, Power, Duty, Restraint. It's the University of California Press, and I go through all of this. But there's a body of a constitutional law that says that it's actually unconstitutional to detain somebody civilly for in a criminal facility, a punitive facility like a county jail. So it may not even be lawful to do that. And so I do think you need to use proper hospital facilities. The next question, intriguingly, is whether you could do that regionally. So let's suppose, say, Alabama wanted to isolate somebody, and they used Alabama authorities to isolate them in a facility in, say, Arkansas. And I'm not sure how allowable that would be, but I think that as a concept, it's a really important and useful concept. I would much rather see that happen there, and probably legally it could work.
Well, thank you very much, Dean Gostin. I really thank you for the way you've set the stage for us to understand things.
Thank you.
Now that we have a common basis for understanding public health ethics, patients' rights, and the right of the public to be protected, let's look more in depth at how TB control programs are using legal interventions. In particular, I'd like you to see how the characteristics of the patient's medical condition, such as infectiousness, the patient's actions, for example, non-adherence, and the health team's careful documentation and legal tools are brought into play. So to see how this is doing, how it's working in New York City, I'd like to turn to Dr. Sonal Munsif. She has worked in TB control since 1992 and is Director and Assistant Commissioner of the Bureau of Tuberculosis Control of the New York City Department of Health and Mental Hygiene, as well as a medical officer of the Division of TB Elimination at the Centers for Disease Control and Prevention. She's very active in research and publishing about tuberculosis control. Dr. Munsif?
Oh, good afternoon and good morning. I am very pleased to be invited to present on New York City's experience. As many of you know, 1980s and early 1990s saw a very massive resurgence of tuberculosis in New York City, with a increase in cases of just over 1,000 in 1978 to almost 4,000 cases in 1992. And there was emergence of drug resistance and multi-drug resistant TB. With transmission in many congregate settings, such as hospitals, prisons, and shelters of both susceptible and MDR-TB. And at that time, in 1992, a comprehensive TB control program was launched. And as part of that, the health code of New York City was revised to strengthen the powers that the Commissioner of Health has to ensure TB patients are evaluated and finish treatment. Prior to that, the health code of the city gave some broad, very general powers to the commissioner, and patients who had infectious TB were detained. But usually once they became smear negative, there was very little that could be done, and there was no due process that was spelled out. So after much debate and review, the health code was revised in April of 1993, and it allows the Commissioner of Health or his delegates, which include several people in the health department, to ensure that the public health or the health of any person is not endangered by a case of TB. The case of TB has to be in New York City, and it could be does not have to be a New York City resident. It could be someone going through New York City or just temporarily visiting New York City, as long as the exposure is happening in New York City. So the health code has specific type of orders that can be that are allowed to be issued. So there are orders for outpatient evaluation and treatment, and we have ended up numbering them based on the order in which they show up in our health code. There is an order for a complete examination for suspected TB, which means whatever the provider feels is the best that is best tests that are needed. There is an order to tell the person that they must complete treatment for pulmonary TB, but it doesn't have to be done by directly observed therapy. Then the other order for outpatient care is what we call a D3 or a CoDot, Commissioner's Order for DOT, which is to take directly observed treatment for people with pulmonary TB. And I'll explain further under what circumstances these things are issued. There are also orders for inpatient care, and the orders are, again, for complete evaluation for suspected TB, but this has to be done in an inpatient setting. A D4 order is given to someone who is known to have TB and who or is highly suspected of having TB based on a smear result from sputum or respiratory specimen, and the person has to remain isolated while infectious. The person has to stay in a hospital setting. And then a D5 order is in order to complete treatment in civil detention, usually after someone has become non-infectious. The orders for examination, the D or D1 orders, allows the health department to remove someone or detain someone in a hospital or other treatment facility as appropriate, and the person's diagnosis of TB is considered highly likely based on the clinical picture, X-ray, and sputum smear results if they're available yet. But the person persistently refuses further medical exam. So they may have had an X-ray, but then not give their sputum, and the person is in close physical contact with others. They may be in a congregate setting, or they may be living with others who are at danger. And again, the provider in a facility, a private doctor in their office, or in a hospital has to identify someone like that and contact the health department and say, okay, here's someone who's refusing, and we think they may have TB. And then we would get all the appropriate records and issue and evaluate and issue an order. A D2 order is something that we don't use too much of, but it's an order given to someone who has confirmed or suspected to have active TB and has been non-adherent early on in treatment, such as leaving the hospital against medical advice or refuses medication or fails to keep their appointments. And it basically tells them that they must take treatment or other actions could be taken. It leaves it up to the patient to decide whether they want to take treatment by DOT or self-administered. And that's why we don't use it very much. D3 order, or CoDot, is given to people with confirmed TB disease, generally pulmonary TB, and their patient is ordered to take treatment via a program of directly observed therapy. And if they're not adherent to DOT after they have been given this orders, then they can receive a warning letter, and after that they can be detained if they still remain non-adherent. And generally, we only give these orders to individuals who have had a positive culture for TB from a sputum or a respiratory specimen as well, actually. During the past years, if someone has had TB a long time ago and now shows up, and had not completed treatment in the past, if they are no longer have active disease, it's unlikely that something like that would be an order like that could be issued to that person. This is the order that's most commonly used, and a lot of attempts have been made to bring the patient into care. They are shown to be unreliable to self-medicate despite having been educated. They've been offered voluntary clinic, home, or field DOT at a site that they want, but they've either refused it or they have been on DOT and not been adherent at least 80% of the time. And they may have had a previous order for detention while infectious, again showing that they had difficulty in keeping in being in isolation and keeping to the requirements that were imposed upon them. So if someone who has an order for directly observed treatment and is on directly observed treatment but does not maintain full adherence, they can get a letter just which spells out that they can be detained if they continue. So they're given a chance, and that sometimes works. Now, the last two orders are two detention orders that are most commonly used. An order for isolation is an order that authorizes the health department, and it's the health police who will do this in conjunction with our staff, take a patient to a facility or ensure that if they're already in a hospital that they are kept in a secure room. It's someone with confirmed or suspected active TB who has, again, pulmonary TB, and who has shown likelihood of transmission because of not being separate from others. They're often in a congregate setting, or they are homeless, but not all. They do not follow anti-contagion precautions that have been advised, sometimes refusing home isolation if they are not homeless. And these orders can be issued on an emergency basis on evenings and weekends by the health department's on-call doctor after reviewing the situation. And it's effective until next business day in such a setting before. And then the TB Bureau staff will review all the information and decide if a formal order is needed past the 24 hours. And person is, once the order is given, then the person is kept in isolation in a secure facility until no longer infectious. Again, the person cannot be forced to take a medication with any of these orders. We do not forcibly medicate anyone. They have to swallow their own pills on their own, and they're held until non-infectious, which is usually 3 negative smears or clinical judgment in certain situations. As part of this, it's something important to understand how this can work, because the individual who's at risk of eloping or who doesn't want to stay in the hospital and is infectious is identified generally in a hospital setting. Most patients with TB are diagnosed in an inpatient setting in New York City, and so the hospital provider is the one who has the responsibility, the obligation to keep the patient isolated as per New York State regulations, and the hospital has to secure a guard, and while we review the records and make a decision about whether to issue a detention order. So sometimes the hospital will call us and say, okay, here's a patient who's we think has active TB, and they want to elope. They want to sign out AMA. What do we do? So, we have to tell them that, look, you have to put the guard there and keep the patient there until we can get the paperwork ready and after reviewing everything. So they can't just let the patient sign out against medical advice, and they have to make sure the patient can't elope. A commissioner's order for long-term detention, in many ways, this was probably the most controversial part of the whole health code revision. In 1993, what this does is a person with active TB who has a positive sputum culture in the past year, or a respiratory specimen if they didn't have a sputum taken, has shown that they've been unreliable in taking their treatment. They've been hard to locate. They've refused to accept the diagnosis of TB, refused to go into care and continue. They may have been detained already while infectious. They have usually been non-adherent to DOT even after having been on a commissioner's order for DOT and even having received a warning letter. The person who is issued a detention order for long-term treatment has many rights. There is periodic judicial review. They have a lawyer assigned to them. We have a contract with the law firm to provide the patient independent counsel. They have the right to request release, the right to a hearing. They have, and there are requirements for periodic review built into the health code, so that initially the first review happens at 60 days, and then after that every 90 days, unless the patient decides that they don't want the hearing, at those time periods. And patient is usually held there until completion of treatment, and occasionally there will be stipulation that they can be discharged or prior to completing treatment if certain conditions are met, and that is not uncommon. For all of the orders, a lot of information has to be reviewed, all the admission notes, provider notes, microbiology results, x-rays, and other studies. If they had eloped or shown any other type of violent behavior, there'll be incident reports that will be looked at. The most useful piece of record, though, is the provider notes documenting the patient's behavioral and clinical factors that indicate the need for detention, that they've tried to educate the patient, counsel the patient, and patient has threatened to leave the hospital AMA. And those are really very most useful in making a decision. In addition, it is also important that the TB Bureau staff have actually educated the patient about tuberculosis and the risks of developing drug resistance and importance of adherence. And usually many attempts have been made to find and educate the patient repeatedly before the person is detained. And all of those, everything that is done is then documented in the order that's issued so that there is a clear history of all the attempts made. The next couple of slides show some data on the number of patients that we reviewed and then eventually served a commissioner's order for various things over this 10-year period. And since then, since 2003, the numbers have remained fairly similar to the last 2-3 years of this decade. As you can see, there was a large number of people that were referred and then were served orders in the mid-90s, and then since then we have had a steady decrease, and this is consistent with the decrease in number of cases in New York City. In 2006, we had 953 cases of TB as compared to over 3,800 cases in 1992. And in the early 90s, many of the patients were patients from prior years that had been non-adherent for many, many years and were now finally being captured through the system and getting orders and getting them to finish treatment. The patient characteristics of this particular cohort was very similar to the average patient profile in New York City. They're young men, many larger percentage, though, are homeless or HIV infected. Had abused alcohol and drugs compared to the overall TB patients in New York City. The type of orders issued is shown here. As you can see, the most common order issued is an order for mandatory directly observed treatment, and then orders to isolate while infectious, and in the order for long-term detention, the D5 orders, where someone could be detained from a few months to as long as 18 to 24 months for some of the MDR-TB patients. This is another way that we looked at our data, which is what percentage of the patients from that particular year actually required orders. And as you can see, the percentage of patients requiring orders has decreased significantly. Fewer percent of patients need orders, but there is a steady percentage of patients who have needed detention. Obviously, the number of patients per year is decreased given the lower cases. The percentage has stayed, and the need to have a facility where patients can be kept in civil detention until treatment completion, therefore, remains. So in conclusion, the referrals for legal action have decreased, reflecting the decrease in cases of the patients that actually were referred. Not all get an order, and only less than 50% of the patients that actually do get any kind of an order ever require detention. About a third of the patients required long-term detention of the ones who did get orders. So, but overall, it's only 1 or 2% of the patients from that particular year that ever required detention. The epi of the patients subject to legal action has changed, and I'm not going to go more into that right now, but it does reflect the totally different patient population with TB in New York City, mostly foreign-born and much less HIV infection and much less homelessness and drug use. But the need for having the capacity to isolate and detain patients remains. Okay, I'm going to discuss a case now that we had recently. This 45-year-old man was admitted for detox for alcohol and cocaine to a New York City hospital and had given symptoms of 2 months of cough and was apparently quite ill, and on further evaluation was found to have smear positive sputum with cavitary TB, and subsequently culture grew MTB as well, and the isolate was drug susceptible. Patient was put on treatment. He was homeless. He had lived in Philadelphia and then spent a few weeks in New Jersey prior to then coming to stay in New York City for a few weeks before he was admitted. And since he was homeless, we offered that after he's non-infectious, that he could be discharged to the TB men's shelter, but he refused and wanted to return to Pennsylvania, to Philadelphia. And so after education and counseling, and this was agreed upon, and the case was referred to the Philadelphia Health Department, and patient went there, we think, but he could not be found for many weeks. He then was admitted to a hospital in Philadelphia where he was found to again have TB. And then the Philadelphia Health Department at that time issued an order for the patient to take directly observed treatment, but he was again lost to supervision in Philadelphia. And in a few months later, he was admitted to another New York City hospital with TB symptoms, again found to be infectious, but he actually eloped from the hospital within a day before the health department, the TB bureau staff could even get to him. Again, a few days later, he was admitted to a third New York City hospital, and this time he was there long enough that the TB bureau staff was able to talk to him, get all this history, and after review of his situation, he was served with a order for detention while infectious, and we actually moved him to our detention ward to Bellevue Hospital. And his chest X-ray had worsened since in the last 5 months since he had briefly taken treatment in December. He, of course, again wanted to return to Philadelphia when he became non-infectious on treatment, and we tried to accommodate this request by working with the Philadelphia Health Department, but the Philadelphia Health Department said they could not receive him from the health police. He would have to come there and show, get in treatment, and if he was non-adherent, then he could be jailed there. But that was their next step after giving the order for directly observed treatment. And we felt that the health police, could not just take him to Philadelphia and leave him there on his own recognizance, since he could not be directly delivered into the hands of the Philadelphia Health Department staff. So after much discussion, we kept the patient in New York City and gave him an order to complete treatment as an inpatient given the long history of non-adherence. And after all this, the patient is actually counted in Pennsylvania and is getting all his treatment in New York City. Just in conclusion, limitations and challenges of doing this are many. We need a designated hospital space for detained patients that has security 24 hours. We had a ward initially at a hospital that was dedicated just for TB detainees who were non-infectious, but after about 8 years, the number of patients were too few to keep a whole ward with all the staffing that went with that ward in this long-term care facility, and the ward had to be closed, and we are now using a ward in a acute care facility at Bellevue Hospital where there are detained patients as well as other general non-detained TB patients and other pulmonary disease patients that are admitted. But the ward is locked. There's security 24 hours, and this allows us more flexibility. We don't, in many ways, but it's an acute care facility which has many other challenges. We have had trouble finding lawyers willing to represent TB patients. There was a great fear about patients being infectious, etc. We've had, because the patients actually get their hearing in a courtroom, when the infectious patients are brought into the courtroom, there is a little isolation chamber in which they sit in to ensure. But even despite that, the lawyers, we have had lawyers that were unwilling to represent patients, and recently we switched to a different law firm because one refused to see these patients. There is a cost built into maintaining the facility where we have the detainees. We are paying for the security. The hospital gets reimbursed for the hospital stay, but we are paying for security, additional staff, as well as many services to provide patient occupational and art therapy and other things and incentives and to keep them busy. If the person is uninsured and is unable to get Medicaid, emergency Medicaid, then we actually pay for the hospitalization directly from our funds. If the patient has is considered to be mentally incompetent, it's very difficult to treat them because a lot of our patients will not even have a proxy. And if they are not able to, make decisions on their own, how do we give them TB treatment? So those are very difficult patients. In New York City, we haven't used detectives or the police to find lost patients, and it's something that we need to explore because we've definitely lost infectious patients that probably if we had used the services of and the skills and abilities of the police department, we probably would have found some patients that have become lost. These regulations cannot be applied to cases of extrapulmonary TB or patients with clinically diagnosed TB. Either, so if they refuse treatment, then there is not much that can be done because they're not a public health threat. So we cannot say, well, they could develop extrapulmonary TB in the future. I'd like to acknowledge the staff that have helped put together a lot of this information. Mark Beatty, while working for the CDC, collected a lot of the data and reviewed all the records. And I did show you only a tiny amount of all the work he did. And the Goldwater Memorial Detention Unit was where we had our patients under detention from 93 to actually 2001. And the current hospital staff at Bellevue Hospital, which is our current detention facility, and that was very useful for us when we got a call that that the bed was needed for Andrew Speaker as he was coming to New York City. We were able to immediately call our facility and get a bed and take care of him. Without that, I think we have to, putting patients in jails is something that, at least for now, we hopefully don't have to do in New York.
Well, thank you very much, Dr. Munsis, for sharing your firsthand knowledge and experience with all of us. The approach that New York City is using is really illuminating for us as we're considering adapting and applying these tools in our own program areas. And as you point out, it's not always easy. Now that we've seen in depth how New York City uses this graduated series of commissioner's orders and careful documentation and a locked ward in a hospital as the last resort, we want to take a look at how another program, the state of Florida, deals with similar issues together with the counties which it assists. I'd like to turn this over to Kim Tendrich, who is the Chief Legal Counsel for the A.G. Holly TB Hospital and the Florida Department of Health. She will also present a case study along with Dr. Michael Lizardo, the Deputy TB Controller, Florida Department of Health, Division of TB and Refugees Health, and an adjunct professor in the Division of Pulmonary Critical Care and Sleep Medicine at the University of Florida College of Medicine. So, Kim?
Good morning, everyone. I always say that I'm very fortunate to live in the state of Florida, not only because we have a lot of sunshine and beautiful weather, but also because we have great TB laws, and that great TB laws require the state to have a TB attorney. So here I am, very fortunate to be here. In Florida, we have legislation called the TB Control Act, and we're given under Florida law a special specific statute. And we manage TB through a number of ways through our court system. We can go to court and petition for an examination and treatment order. We can petition for directly observed therapy. When I say we, I mean the Department of Health and the county health departments. We can petition the court for hospitalization and isolation orders. We can petition the court for two types of emergency hold orders and an involuntary hold order, and I'll examine them more in depth throughout my presentation. The TB Control Act does list specific definitions. Active tuberculosis under Florida law is defined as tuberculosis which is considered active until cured. Treatment to cure is also defined in the definitions, which means the completion of a course of anti-tuberculosis treatment. And it's the doctor's call whether or not there is a treatment to cure and whether or not the TB has been treated effectively. And then directly observed therapy. It's when the health department representatives watch the individual take the medication. In 1994, Florida legislature abandoned the element of proof which required a patient, in order to be isolated, to be infectious. That was a problem when we would go to court, when the Department of Health would go to court and try to prove cases. In 1994, our medical director went to the Florida legislature and spoke to them about the definitions and how it needed to be changed from an infectious TB to active TB. Now, currently, Florida law only requires that a person have active TB to come with under the confines of our law. That is TB which is diagnosed as contagious by clinical or bacteriological evidence, and the person is deemed active until cured. That made the lawyers within the Department of Health life so much easier to present cases to court for isolation orders or for treatment orders. Active TB is not necessarily in an infectious state. When the case in the spring of this year came up, there was a lot of discussion as to whether or not he was contagious, infectious, things of that nature. Under Florida law, that would not be relevant when we were going to court for legal action. What is cured? Cured is defined as the completion of a course of anti-tuberculosis treatment. Once the Department of Health confirms the existence of TB, or a lab confirms, or a medical doctor confirms TB, the health department then becomes notified. The patient is counseled about the disease and signs an acknowledgement of counseling form. The patient is then placed on a treatment plan. So now what? The individual has been diagnosed with TB. They've been informed that they have TB. They are put on a treatment plan, and the individual complies with treatment, infection control procedures. They never miss a directly observed therapy appointment, and they never miss medical appointments. It's a perfect world and everyone is happy. But that's not the way it exists in reality. And if it was, I'd have no job. But that's not the way it exists in reality. And if it was, I'd have no job. It's not a perfect world because not everyone is compliant with treatment. And that's when legal intervention and when the Department of Health legal team comes into play. We have to examine what constitutes noncompliance before we pursue legal intervention. A refusal or failure of an individual to take medication, to keep appointments, to complete treatment, to abide by physician's orders, or to disregard infection control procedures lead to noncompliance. We've had cases within the state where patients have been compliant with medication. They have attended all of their medical appointments. They have instituted proper infection control procedures, but they're abusing alcohol and drugs. And in a case like that, they're not compliant with physician's orders, and therefore we can pursue legal intervention in those instances. Behaviors of noncompliance provide the evidence that the Department of Health and the county health departments need in order to pursue legal intervention. How do we in Florida begin the legal process? There's a couple ways. We need to obtain either one of the two hold orders which exist under the law. One is called an emergency hold order, and the other one is referred to as an involuntary hold order. An emergency hold order is valid for a 5-day period, and those are 5 business working days. It's primarily used when a patient's been diagnosed with TB and their whereabouts are now unknown. It's not required that the whereabouts are unknown, but these are the circumstances in which it usually comes into play. If a patient has a history of noncompliance and they've been counseled about the disease and they exhibit by words or actions that they will not appear for a hearing on a petition for a commitment or on a petition for treatment order, then the local health departments file a petition for involuntary hold. What this does is it notifies the local sheriff's office. And as Sonal said in her previous presentation, that they don't necessarily have the utilization of the sheriff's office or the police force in locating patients. In Florida, it's different. Once an emergency hold order is filed, the local police authority, the sheriff's office, is notified of that order, and the order goes out to the deputies. And the deputies are placed on notice to try to locate that individual and confine that individual in some type of detention facility, if it's a jail or if it's a medical facility, whatever facility is used in that specific county. And that hold order takes effect the minute the person is apprehended. So the 5 days do not begin until the person is actually physically detained and held. An involuntary hold order is used in a strict set of circumstances. It's when a patient has been diagnosed with TB and a patient is non-compliant. However, they are then located in a medical facility or treatment facility. What we can do at that point in time is the treating physician can sign what's called an involuntary hold order, and the TB control officer for the state of Florida also signs that involuntary hold order, and that person is then kept in that medical or treatment facility in which they arrived at when the hold order was signed. These usually come into play when a patient has been lost to treatment and they appear in an emergency room of a hospital, or they show up at a health department seeking treatment and they have been non-compliant. These types of orders are really important, and they were modeled after our mental health orders of the state of Florida, because at the time that they're executed and at the time that they take effect, they do not require judicial intervention. So we could have the treating physician and the state health officer sign that order, and it has the force of an effect of a legal order for a period of 72 hours. And after that 72 hours, or within that 72 hours that the hold is in effect, the individual is brought before a judge for a hearing on this matter. And another note, I know that Dean Gostin and Sonal spoke about due process, and within our statute, TB patients are afforded right to counsel, and they're also brought before a court before any legal action is taken for treatment or isolation. Once the patient has been located and held under one of the two orders, then a hearing is held on either court-ordered DOT or isolation. Now, court-ordered directly observed therapy is typically utilized when a patient has missed a few directly observed therapy dates, or when a patient has been somewhat inconsistent in attending clinic visits or been a little inconsistent in taking the medication. This is typically used in a case where you don't want to commit a patient to the hospital because you want to use the least restrictive alternative. But it's used when the health worker, the health department thinks that the patient needs to take their treatment a little more seriously than they're currently doing. These petitions for court-ordered directly observed therapy last for a period of 180 days. Petitions for hospitalization, they also last for a period of 180 days, and this is an isolation petition. In the state of Florida, we're fortunate to have a hospital that treats strictly TB patients. It's an acute care hospital, and TB is the primary diagnosis for admission. When the court orders a patient to be committed to A.G. Holly Hospital, the order is for no more than a period of 180 days. If a patient is multi-drug resistant or has some concomitant illness which requires treatment longer than 180 days, the Department of Health can renew that order for an additional 180 days and continue renewing the order until the patient is treated to cure. The patient, in order to be a candidate for petition for hospitalization, there are a few elements that must be proven by the Department of Health. That the patient has been diagnosed with active TB, that the patient has been counseled about the disease, and despite such counseling, they continue to be a threat to the public health, and there's no lesser restrictive alternative that exists. At this point, I'm going to turn the presentation over to Dr. Lizardo, and he is going to present an extremely factually interesting and challenging case that his local health department has handled in conjunction with another state. Mike, you're up.
Good afternoon. Just wanted to present, as Kim said, a very interesting case. And again, I want to thank you all for joining us this afternoon. The patient is a 37-year-old Asian woman who originally presented to her primary care physician 2 years earlier with a complaint of cough. A PPD was done at that time, which was positive at 20 millimeters, and a chest x-ray done in response to that 20 millimeter PPD and symptoms of cough showed a right upper lobe 3-centimeter nodule with some questionable fibronodularity associated with it. In response to this, in a follow-up visit shortly thereafter, the patient was told that TB should be ruled out. At the suggestion that this might be tuberculosis, the patient's husband, who, by the way, provided all the history and was the one who was more capable with English, became angry, and they went to see a pulmonologist and on their own. The primary care physician did not hear from that patient for about a 2-year period of time, but then 2 years later, the patient returned to her primary care physician with the same complaints, but this time she was coughing up blood. In fact, I'm putting it mildly there. Apparently, the staff from the clinic came into the physician's workroom and said there's someone spewing blood all throughout the waiting room. So it was a very dramatic moment. So because of that, arrangements were made to have the patient immediately evaluated in the hospital to rule out tuberculosis. You can look at the chest x-ray. Shows that there's a 3-centimeter nodule in the right upper lobe, and the subsequent slide to that shows that there's an area of fibronodularity. So it's not a typical x-ray that you would expect with the presentation of hemoptysis, but it is certainly consistent with tuberculosis in the findings of cough as well as a positive PPD. So the patient's husband became extremely upset that TB was mentioned again and stated that TB was impossible since his wife had received BCG in the past. The patient and the family at that point went into hiding. When the primary care physician was reviewing the chart, they finally got the note from pulmonary, and at that time the note from pulmonary 2 years earlier stated that the PPD and chest x-ray abnormality was from BCG. Patient's past medical history was significant for allergic rhinitis, which was the diagnosis that was carried from previous. Patient was on decongestants and nasal steroids as the only other medications. The social history, the patient was born in China, had been in the United States for almost 10 years with travel to and from China. She volunteered at a school and was a homemaker with 2 kids. Her husband was a professor at a major university and had a medical degree from China, although he was on staff in the engineering department. So I'll pause here and have Kim address the question about what would be the next steps.
The next step in this situation is the Department of Health attorney, based upon the epidemiological and clinical evidence, decided to pursue an emergency hold order on the case. The patient was being non-compliant. There were signs that the patient was positive for TB based upon the cough, the positive PPD, and, as Mike said, the spewing of blood in the waiting room. With that emergency hold order, the sheriff's office attempted to execute the hold order to locate the patient at her home and to transport her to a medical facility to be held until a hearing was held for isolation or directly observed therapy, court-ordered. However, in this case, it proved to be problematic because the family was not cooperating, and when the sheriffs tried to execute the hold order, the patient was gone. The patient apparently had fled to California and was nowhere to be found, even though the husband remained. Mike, do you want to take it from here?
Yeah, I would. In fact, there was some color commentary here. It's that, and now it's time for true confessions. The primary care physician actually happened to be my wife, and she had reported the case to the health department by talking to me when we were on our way out to dinner the night of the incident. And eventually, we had spoken to the patients about that. They realized that the last names were the same, and then that only fed into more of the husband's paranoia. And it made things even more complicated because then there were very many colorful conspiracy theories that came about. But nonetheless, we had pursued an emergency hold order and tried many ways to get the patient to be evaluated voluntarily. I will also add that we had made arrangements with trying to be accommodating to cultural barriers and some language barriers with the patient, not with the husband, to have the patient evaluated in a hospital of their choosing in the city where they resided. They actually sent an imposter who, on checking their ID, we realized it wasn't the patient, but it was someone else who was going to present sputums in lieu of the patient that was suspected of having TB. After the sheriff's office was involved, but the patient could not be located, and after 2 weeks the patient surfaced. The long and the short of it is that the patient finally gave sputum in California to her sister, who worked in a laboratory at a medical school. There were a bunch of other rocky starts over the next, during the 1 month interval between their departure from Florida to California. But nonetheless, sputums were obtained. And then the next call that I received was from the Orange County Health Department in California, which said that they needed to call me about an interesting case. They had a 2+ smear positive on AFB. Cultures were confirmed as being TB, and because of the history of what occurred in Florida and what had also occurred in California, court-ordered treatment in California for directly observed therapy and for hospitalization for, I believe it was about 3 weeks, was started. The husband then reported to the health department here in Florida, was very contrite and very apologetic, and the best way to describe it was he felt ashamed in his words. He had a chest X-ray done and the PPD. His chest X-ray was abnormal. Sputums were smear positive and culture positive as well. Both of their children were infected but did not have evidence of active disease. DNA fingerprinting matched both adults. This is the husband's chest X-ray, and you can see the bilateral apical infiltrates. I guess the points that I really wanted to make here is that from a medical standpoint, you need to suspect and pursue the diagnosis of TB with chronic respiratory symptoms in those who fall into high-risk categories. As Kim had mentioned earlier, state law mandates that patients confirmed or highly suspected of having active TB be treated and or isolated until cure, regardless of whether or not the diagnosis has been established. Suspicion is sufficient as long as it's justifiable. And cultural factors may pose barriers to treatment. In fact, I'm always somewhat apprehensive in presenting this case because it smacks of, we're missing something. There were some cultural factors, there were some barriers, but our efforts to engage the community from which this family came from, they were the members of the community that were facilitating this investigation were just as perplexed at the behavior. So there are things that supersede cultural barriers that can present very, very significant challenges. So I will go ahead and stop here, and then also go ahead and take some questions along with Kim if that's appropriate at this time.
Well, thank you very much, Kim and Michael, for sharing your knowledge and experience with us. The legal frameworks you've got for intervening in TB control and the relationship between the state and county levels brings out some important lessons for all of us. I would like at this time to take, let's say, 2 questions addressed to Kim, Michael, and to Dr. Sonal-Munsif so that we can look at all of the program examples and cases we've had. Operator?
Hugh Tyson with the county department. Your line is open.
Yes, I'd like to ask how you deal with a mentally incompetent person who really can't understand what's going on, and you need to treat them for active TB.
I can answer that question from the Florida perspective. I can answer it from the Department of Health's perspective and not necessarily the local health department. When we receive a mentally incompetent patient, we actually have a psychiatrist on staff at A.G. Holly, and he evaluates the admissions that come in. And if the patient is, in his opinion, deemed to be unable to make reasonable decisions for their medical care, we go to court and we secure a guardian for the period of time that they're here for treatment. Typically, when I get calls from local health departments stating that they have a patient that they believe may have some issues regarding competency, they will go ahead and commit the patient if the patient meets that criteria for noncompliance, and then we'll get the guardian here. We're very fortunate that we do have a local attorney that serves as guardian for our patient, and she's very informed as to the TB treatment that's necessary and mental health issues.
I noticed at this point that there's been no discussion or no reference to contacts exposed to infectious cases. Several years ago, we conducted a national survey here in New Jersey and asked TB controllers in each state what regulations they had regarding cases and contacts, and we found that only 1/3 of the states responding to the survey indicated they had regulations mandating contact adherence. So I'm wondering if that should be a concern of ours nationally.
Hello, this is Sonal Munsif. I would like to just respond to that briefly. Even though we have in New York City the ability to issue an order for examination for someone with suspected TB, since most contacts are asymptomatic, it's very difficult to, do anything for them if they refuse evaluation. If they have symptoms of TB, then we can do something, or if there's a high-risk situation, we may pursue something if there's been a part of an outbreak investigation. For children, for minors, we go through the Child Services Department because if their parents are not, or guardians are not taking them for medical evaluation, then they can be referred for medical neglect. So for children, we do pursue that option regularly and work with the Agency for Child Welfare Services to ensure that they are evaluated and put on prophylaxis and preventive treatment. But for adults, it's much more difficult, and there should be some options, at least to get them evaluated.
The same goes here in Florida. This is Kim. We have under our Florida statutes a physical exam and treatment. So if during a contact investigation a person presents themselves to be having some symptoms of TB, then we can go to court and pursue a warrant for their examination for them to participate in a contact investigation. And with the children, when it comes down to the children, it's the same thing. We report them if a parent is not pursuing medical care or they're not allowing them to participate in the contact investigation. A report is made to the State Department of Children and Families for medical neglect.
That's all the time that we have for it now. What we'd like to do now is take the discussion to the last level, which is that of federal intervention. I'm going to call on Dr. Francisco Everhoff. He's worked for many years in the U.S. in family medicine and primary care, and internationally in epidemiology, policy, and the control of infectious diseases. Currently, he's chief of the Quarantine and Border Health Services branch of the Division of Global Migration and Quarantine at the CDC. Dr. Everhoff?
Thank you very much. And thank you for this opportunity to discuss federal quarantine and isolation authority. Public health has several tools available to protect public health. Today I'll focus my discussion on federal use of isolation and quarantine as it relates to tuberculosis, but we'll also mention some new public health tools available for disease control. I think Dr. Gost already went over these definitions. However, I do want to point out that both isolation and quarantine may be conducted on a voluntary basis or compelled on a mandatory basis through legal authority. The practice of quarantine as we know it began in the 14th century in an effort to protect coastal cities from plague epidemics. Ships arriving in Venice from infected ports were required to sit at anchor for 40 days before landing. This practice, called quarantine, was derived from the Italian words for 40 giorni, which means 40 days. When the United States was first established, little was done to prevent the importation of infectious diseases. Protection against imported diseases fell under state and local jurisdiction. Individual municipalities enacted a variety of quarantine regulations for arriving vessels. State and local governments made sporadic attempts to impose quarantine requirements. However, continued outbreaks of yellow fever finally prompted Congress to pass federal quarantine legislation in 1878. This legislation, while specifying that federal regulations could not conflict with state regulations, paved the way for federal involvement in quarantine activities. Outbreaks of cholera from passenger ships arriving from Europe prompted a revision of the law in 1892 to provide the federal government more authority in imposing quarantine requirements. The following year, Congress passed legislation that further clarified the federal role in quarantine activities. As local authorities came to realize the benefits of federal involvement, local quarantine stations were gradually turned over to the U.S. government. Additional federal facilities were built and the number of staff was increased to provide better coverage. The quarantine system was finally fully nationalized in 1921 when administration of the last quarantine station was transferred to the U.S. government. In this slide, quarantine inspectors are shown in public health service uniforms. The Public Health Service Act of 1944 provided a clear statutory basis for the federal government's quarantine authority for the first time. The Act gave the U.S. Public Health Service, or PHS, responsibility for preventing the introduction, transmission, and spread of communicable diseases from foreign countries into the United States. The Health and Human Services Secretary, or HHS, has statutory responsibility for preventing the introduction, transmission, and spread of communicable diseases from foreign countries into the United States. For example, at international ports of arrival and from one state or possession to another. This authority has been delegated by the Secretary to the Director of CDC. The federal quarantine statute is codified at Title 42 of the United States Code, Section 264. It authorizes the apprehension and examination of individuals to prevent the spread of communicable diseases. In addition, this authority includes the possibility of conditional release of persons from quarantine on the condition that they comply with medical monitoring and surveillance. The statute authorizes the quarantine or isolation of individuals arriving from foreign countries, Part 71, and moving between states, Part 70. In order to quarantine interstate, the suspected individual must either move or be moving or about to move between states, or to be a probable source of infection to persons moving between states. They must be in a qualifying stage of the disease, which is defined as either a communicable stage or a pre-communicable stage if it is likely to cause a public health emergency. The federal government has the authority under the Commerce Clause of the U.S. Constitution to prevent the interstate spread of disease. State, local, and tribal jurisdictions have primary responsibility for isolation and quarantine within their borders, and there is no state preemption unless there is a conflict with the exercise of federal authority. It is possible for state, federal, local, and tribal health authorities simultaneously to have separate but concurrent legal quarantine power in a particular situation. An example might be an arriving aircraft at a large city airport. Although the current statute does not specify any hearing provisions, the traditional method for contesting one's detention by the federal government is through habeas corpus. Proposed modifications for the updated federal regulations, the Notice of Proposed Rulemaking, specifically provide for additional administrative procedures for individuals under federal isolation and quarantine. The communicable diseases for which federal isolation and quarantine are authorized are set forth through executive order of the President and include cholera, diphtheria, infectious tuberculosis, plague, smallpox, yellow fever, viral hemorrhagic fevers, and severe acute respiratory syndrome, or SARS. In April 2005, the President added to this list influenza caused by novel or reemergent influenza viruses that are causing or have the potential to cause a pandemic. Additional communicable diseases may be added. Other relevant sections of the Public Health Service Act include that the federal government may assist state and local jurisdiction in enforcement of quarantines or other health regulations, may accept state or local assistance in enforcing federal quarantine, that the U.S. Customs or Coast Guard shall aid in the federal quarantine enforcement, that the federal government may care and treat quarantine individuals in a public or private hospital. The statute also provides for criminal penalties. For example, persons may be fined up to $250,000 or be sentenced to 1 year in prison or both. Organizations may also be fined. Federal isolation and quarantine has rarely been used since the influenza pandemic of 1918-1919. Until this year, the last exercise of federal quarantine was in 1963, when a passenger arriving in the United States suspected of having smallpox was placed in isolation. In May 2007, as you all know, and we've referred to in this conference, a traveler with drug-resistant tuberculosis was placed in federal isolation in a highly publicized event. Much of our work at the ports of entry consists of assisting state and local health departments in the control of imported infectious tuberculosis. This map graphically illustrates the origin of flights entering the United States with a passenger with infectious tuberculosis. During the period of mid-2005 through mid-2007, the Division of Global Migration and Quarantine has been notified and assisted in the investigation of over 120 cases of passengers with suspected infectious tuberculosis entering the United States. Those instances which are considered high risk for transmission, flights over 8 hours, are investigated in collaboration with the Division of Tuberculosis Elimination and state and local health departments. The vast majority of these cases are identified after entering the United States and being diagnosed and reported through state and local disease reporting mechanisms. And as noted, the use of federal isolation and quarantine is rarely needed. Interestingly, following the high-profile multi-drug resistant investigation during May and June, we've experienced a large increase in reporting of such cases. Some additional tools available to assist in the control of infectious diseases, including tuberculosis, include Public Health Do Not Board and Border Lookouts. Do Not Board allows CDC to recommend to the Department of Homeland Security, or DHS, to deny boarding of persons on aircraft entering or leaving the United States or between U.S. states who have infectious diseases and may pose a risk of transmission to fellow passengers and crew. Border Lookout is a CDC request to DHS to be on the lookout for persons at U.S. ports of entry with infectious diseases who may pose a risk of infectious disease transmission to others and or have not been compliant with public health recommendations to prevent transmission to others. The authority for these actions include, in addition to the Public Health Service Act, Federal Quarantine and Isolation Regulations, the Immigration and Nationality Act, and the Aviation and Transportation Security Act. The initial steps in utilizing these tools require state and local health departments to contact and work with the quarantine stations in their jurisdiction. In summary, Federal Quarantine Authority exists and is available to control the spread of infectious diseases at our ports of entry and for interstate control of infectious diseases, although this authority is rarely needed. Additional tools for control include Border Lookout and Do Not Board. These tools are utilized in collaboration with the CDC and the Department of Homeland Security. Federal Quarantine Authority can supplement and support state and local authorities. There is a need for judicious use of these actions to balance the public good with restrictions on the individual. This map illustrates the location of the 20 quarantine stations and their jurisdictions. Modern quarantine stations have been selected largely on the basis of air traffic. However, land border stations are also included. Quarantine stations have regional responsibilities. For example, an event involving Denver International Airport would be the responsibility of our Seattle quarantine station. Events along the Mexican border in California and Arizona are the responsibility of the San Diego quarantine station. For contacting us regarding any issues related to federal isolation and quarantine, use of Do Not Board or Border Lookouts, please go to the links on the slide identifying the quarantine station in your jurisdiction, or if an emergency or after hours, please call the CDC Emergency Operations Center or EOC at the number listed. Thank you.
Okay, operator, I think we have time for one question for Francisco Eberhoff.
Stephen Dye, Valley State Prison, your line is open.
This question had to do with the amount of individuals. I went to a conference in Atlanta, and I found it very interesting that 3/4 of the individuals that were crossing our borders from various parts of the country were causing the larger amount of TB cases that we had here. When they say infectious tuberculosis, does that mean LTBI, or is that actual tuberculosis that's under treatment?
Yes, infectious tuberculosis means that they would be in an infectious state, so it would not include LTBI.
Well, thank you very much, Francisco, for sharing with us the perspective of your division. It's really helpful to know that global migration and quarantine is there to back up state and local programs in case of need. Now that we've explored the whole range of legal interventions, from the local to the state to the federal levels, let's open it up for some more questions from participants for all of the panelists at this time. Operator?
Yes, sir. John Workington with Tennessee Department of Health, your line is open.
Thank you very much, and thanks to all the presenters today. This is directed primarily to Florida and New York City jurisdictions. Do you have precedent for using your public health authority for undocumented immigrants with active tuberculosis that happens to be infectious? And secondly, do your local jurisdictions, New York City or the state of Florida, pay for treatment until cure while under detention?
Yes, in New York City, we will pay for treatment for anyone who's in a New York City hospital who cannot get emergency Medicaid, regardless of their legal status. And yes, we are able to detain or isolate infectious patients regardless of immigration or status, even if they're visitors or here illegally.
In Florida, it's the same thing. Patients are treated here at the hospital, and if they have Medicaid, then we apply for the Medicaid, but they're treated here until cured, so they could be here for 6 months to longer, and the state of Florida pays for their care the entire time they're here if it's not covered by an HMO or Medicaid or in private insurance. And the same thing holds for illegal aliens.
Karen, the Arizona Department of Health, your line is open.
Yes, Mr. Gosselin had mentioned about having someone confined in jail may be unconstitutional, and there's a couple of concerns. Number one, that there's only about 4 TB facilities throughout the whole country. Most of the people that I have surveyed unofficially say no, they either don't have a place or jail. But more importantly, in July, the Wisconsin Supreme Court ruled on a case where a non-compliant TB patient was in jail, and they ruled that in certain circumstances it can be the least restrictive alternative. And so I just wanted to get a little more feedback on that, because if it is indeed unconstitutional, we have a looming crisis on our hands.
This is Kim from Florida. Since we don't keep our patients in a jail facility, a lockdown facility for treatment, I mean, some counties hold them there because they don't have local hospitals, the real small counties, just for a period of isolation, no more than 5 days. But we don't run into those cases where they're held in a detention facility for treatment.
Why would the local county not keep them in the hospital for isolation rather than a jail?
I can't address it from the local county. I can only surmise that they put them in the jail because there's no hospital within that county jurisdictional.
And also, this is Mike Lazard. I'll comment on that, because a lot of the counties that I cover have that issue. And what many of them use as a justification is that is a cost issue, is that it's too expensive for them to pay for their care in the hospital. And then on the flip side, the hospitals are pressuring them to be discharged. So the county TB program is in the unenviable position of having an active, perhaps non-adherent patient with TB that is going out into the community that they can't keep in the hospital or forced to stay in the hospital because there's no agreement with the given hospital. In Florida, as Kim has mentioned, we're very fortunate. That's usually a passing issue that lasts a matter of day or days until they can get committed to the TB hospital. But that's been the issue. The other flip side is that some, by no means the majority, some of these patients have legal issues involved with them as well, and that has been the justification in some cases as well.
Thank you very much. That is all the time that we've allotted for the seminar today, and I really want to thank the faculty for sharing their knowledge and experience, and thanks to the participants for really a lively discussion, lots of questions and input. There are several resources related to this topic available from the Northeastern RTMCC, other RTMCCs, and the Centers for Disease Control. The Global TB Institute, as well as all of the RTMCCs, provide medical consultation services. For example, in the Northeast region, you can call 1-800-4TB-DOCS with any questions requiring medical consultation. This concludes the conference. Thank you very much for your participation.